Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. Implementation of agreements with foreigners. From the point of view of Indonesia, all fisheries resources within Indonesian archipelagic waters and territorial seas fall within its national jurisdictions. These resources include those of sedentary species found in the Indonesian continental shelf or those of pelagic or demersal species found in the area which would become Indonesia's exclusive economic zone. This position is well known to everyone, therefore, merely have to refer to the Indonesian Declaration of 13 December 1957, announcing the Indonesian archipelagic state concept and the 12 miles territorial sea, but later enacted into law number 4, 1960. In 1961, Indonesia also ratified the Geneva Continental Shelf Convention of 1958, thus acquiring sovereign rights over the sedentary species of all living resources within its continental shelf. The essence of the archipelagic state concept is the recognition of the right of an archipelagic state like Indonesia to draw straight archipelagic baselines connecting to the outmost points of the outermost island of the archipelago, thus enclosing the whole archipelago into a single entity. The territorial sea, the contiguous zone, the exclusive economic zone, and the continental shelf of the archipelagic state shall be measured outward from these baselines. The waters within these baselines are archipelagic waters, over which the archipelagic states exercise territorial sovereignty. The sovereignty covers the waters, the airspace above the waters, the seabed and subsoil, and all other resources contained therein. Derived from this basic concept, especially from the concept of sovereignty over all the natural resources contained in the archipelagic waters, the archipelagic state exercises sovereignty over all the fisheries resources within its archipelagic waters. Thus, any exploration or exploitation of these resources in accordance with Article 33 of Indonesia's 1945 Constitutions can only be undertaken for the benefit of the Indonesian people, either by their own organization or through some kind of arrangement with foreign organization. Any agreement concluded with foreign countries on this matter will have to take into account this basic position. First, through the years in the Indonesian archipelagic state concept has found its way into the ICNT. For detailed regime of the archipelagic state concept, which I hope will be incorporated in the next LOS convention, see Article 46 until 54 of the ICNT. Since the whole archipelagic waters now belong to the archipelagic state of Indonesia, all national legislation with respect to fisheries in its waters can now be applicable to the Indonesian archipelagic waters and territorial sea. This legislation is either of recent origin or dates back to the colonial era. Some of the old legislation now applicable to the archipelagic waters of Indonesia is worth mentioning. First, there is the Pearl and Coral Collecting Act of 1960, which regulated pearl, anemone, and coral collected within 3 miles from the coast. Exclusive and traditional rights for such activities are guaranteed local fishermen anywhere in the sea where depth is less than 9 miles at low tide. Such right cannot be transferred to other except as provided for in the Act. Second, State Gazette 1916, number 157, date 29 January 1976. There is the Fisheries Act of 1920, which prohibits the use of poison, toxins, and explosives in fishing except for authorized scientific purpose. Third, State Gazette 1920, number 396, date 20 May 1920. That is the Coastal Fisheries Act of 1977. The rules enunciated in this act relate to fishing in the Indonesian territorial seas, then fixed at 3 miles from low tide along the coast. The act stipulates that only vessels flying the Indonesian flag and manned by a crew of Indonesian nationals, unless granted special permissions by the Minister of Agriculture, shall be allowed to fish in the Indonesian waters. All fishing activities in the Indonesian waters shall respect and take into account the traditional fishing rights of the indigenous coastal population, as well as the specific rights of local governments to regulate fishing along the coastlines under their respective jurisdictions. This act has been amended several times, the latest having been in 1960, when both the Indonesian archipelagic states principle and the 12 miles territorial sea were enacted into Law Number 4. Fourth, State Gazette 1927, number 144, the Whaling Act of 1927 regulates whaling within 3 miles of Indonesian coast. The act states that whaling within 3 miles of the coast, now within Indonesian archipelagic waters and the 12 miles territorial sea, is allowed only under special permission from the President of the Republic, except whaling activities traditionally conducted by the indigenous coastal population. The Act further regulates all other details related to whaling. Fifth, State Gazette 1927, number 145, date 29 April 1927, the Territorial Sea and Maritime Circle Act of 1939 regulates Indonesian territorial sea 3 miles from the coast at low tide or from straight baseline where there are bays, river mouths, or estuaries less than 6 miles wide, or where there are island fringes along the coast, or where there is a strait less than 6 miles wide, and both if of its coast belong to Indonesia. The Act also established Indonesian maritime circles along specific area within Indonesian coastlines. Fishing activities are prohibited within the maritime circles except by the Indonesian indigenous population or by those with special permission from the naval chief or staff. The Act also established strict guidance from the naval chief of staff in granting the permission to fish within the maritime circles. Presidential Decree Number 103, issued 27 May 1963, provides for the conservation of all Indonesian waters into a single maritime circle. This decree strengthens the power of the naval chief of staff to enforce all fisheries legislation in all Indonesian water. 6. State Gazette 1939, number 442, violators of all or any of the acts cited above are either fined or jailed. Some of the recent regulations on fishing in the Indonesian archipelagic waters and territorial seas contain provision on the use of equipment and the use of trawlers in specified areas, as well as provision on the maximum use of fishery resources. In 1975, the same minister issued a decision setting up guidelines on the proper conservation and management of the fishery resources. This decision regulates seasonal or aerial closure of certain fishing grounds to one, some, or all fish species, as well as the kind, size, and number of vessels, the size of nets, and all other fishing equipment and the quota of each catch. Decision number 2, 1975 prohibits trawling in waters less than ID deep around the coast of Irian Jaya, shrimp catching through the use of pyro trawl, as well as cod ants having a mass size of less than 3 cm stretch mass is also prohibited. The Director General of Fisheries is authorized to determine every year beginning 1 April the number of vessels allowed to operate after the stock of fish or shrimp in the area has been assessed. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.